I'm Ben Meiselas from Legal AF, joined by co-host Karen Friedman Agnifilo. Fulton County District Attorney Fani Willis is, I think, really taking command of this prosecution in the sprawling RICO case in Fulton County, Georgia, against Donald Trump and 18 other co-defendants. I think she's making it very clear to the judge, who's been great, but also has only been a judge for about 6 months so far, and everybody, that nobody in Fulton County, Georgia, knows processes and procedures in Fulton County like Fani Willis. And we did another duet, Karen and I, where we pointed out an incident where Fani Willis informed the court, hey, just so you're aware, if defendants want to try to sever their cases and proceed individually, they can't just happen automatically. There has to be a process and procedure. And judge, here is the procedure that exists in Fulton County. And here's what the defendants should do. So then the defendants all started filing severance motions. And I think it being exposed for, I think, not having great arguments why the cases should be severed, but she kind of forced that issue. I think she's doing a similar thing here. She filed this motion. It's called Motion for Court to Advise Defendants of Effects of Speedy Trial Demand upon evidentiary and procedural rights and brief in support. In many ways, Karen, it kind of feels like it's somewhat of a made up motion in a way, but, and it could possibly be phrased as a notice. But I think what she's addressing here is, judge, we have all of these co-defendants, a lot of them, Ken Chesbrough, Donald Trump's co-defendant, a former lawyer. You got Sidney Powell and some others who have filed these speedy trial demands, which is there's speedy trial demands that exist at the federal level, which is under 70 days, and which is a Sixth Amendment right, has been interpreted by the federal statute on the Speedy Trial Act. And then there's speedy trial acts in the various states that you have a right to a speedy trial. But like in Georgia, it's extra speedy. Like the case has to go to trial. A jury has to be impaneled in the current term or the next term. And these terms are very close to each other. So when a defendant like Ken Chesbrough in this RICO case makes this demand for speedy trial, that means the case has to start before November 1st, basically. And Fulton County District Attorney Fani Willis, previously, we talked about this in a duet that you and I did. She said, like, I'm ready to go. I am absolutely ready. Let's do it October 23rd. But here, I think so that none of these co-defendants of Donald Trump who want the speedy trial, that they can ever argue, oh, we didn't know about this or we weren't properly advised, and then try to appeal like they didn't get all of the information. She just wants to be very transparent, right? And she's like, look, just so you know, you've invoked the Speedy Trial Act in Georgia, but it is going to limit certain things. So be aware of it. Judge, tell them about those things so that we're not in a situation 2 weeks, before trial or more, and they're saying, oh, you're supposed to do this, you're supposed to do that. We don't want to be in that situation. So she's not only ready to go for trial, Karen, but she's saying, just be aware of what you just did, and I don't want to hear you complaining about it later, huh?
Yeah, look, I have to say, I love Georgia Speedy Trial Act. I tried a lot of cases as a prosecutor. I spent 30 years trying cases, really, most of it. And I never went to trial in a case earlier than a year, I would say, sometimes 2 years. I mean, cases just took time, we used to say, to marinate, and it wasn't usually the prosecutor asking for the delay. It was usually a defense attorney saying, oh, I'm not ready, or, oh, I want to make motions, or, oh, I might want to, hire an expert. And, to be fair, 98% of all cases in this country plead guilty and don't go to trial at all. And so that's why cases typically marinate or go on for a while, because, sometimes defendants need time to get comfortable with the fact that they are going to plead guilty. And so cases just typically take they just have like a cadence or a period of time that it takes, and different jurisdictions are different. In Virginia, for example, there's a federal court there called the Rocket Docket. Those cases go much faster. In Georgia, though, as you said, these are just super speedy. I've never seen anything as fast as this. But honestly, I love it. I think there should be more speedy trials. I think, the stain of having a criminal case hanging over a defendant's head, especially one who claims that they're innocent, an accusation is almost as bad as a charge, as being found guilty. And so the quicker you do it, the better. Witnesses, memories fade, cases don't get better for the prosecution with age. And so if you've got defendants who want a speedy trial, I say we should have much more of this in this country. But by doing that, unfortunately, there's a risk. There's a risk that, you won't have time to do certain things. And that's serious too, because there's a due process right to make sure that a case is prepared properly and that you have a proper opportunity to defend yourself. And so what Fani Willis realizes, for a prosecutor, the worst thing that could happen is your case gets reversed. It's great to get a conviction, but if it gets reversed, then what was it all for? And so there are times when prosecutors are protecting the record so that their case will not ultimately get reversed in the future. And that's what clearly Fani Willis is doing here. She's protecting her record, and she's basically saying, look, I just want everyone to know I'm giving over discovery by September 15th if the lawyers give me the hard drive big enough to hold all the documents. Also, I just want everyone to know that the defendants have waived this. There's a 10-day notice of discovery requirement in the law. And if I fail to produce some discovery, I'm going to give you everything by September 15th. But if I fail to do this, then you forfeit. You're still obligated to go forward, and you're barred from objecting to certain things like introducing witness testimony. If you want to claim that you didn't have enough notice, unless you can show that I acted in bad faith, but otherwise, you have to go to trial. And even if you claim that you don't have adequate time to review. But if you think you don't have adequate time to review, then you have to ask for the continuance. Otherwise, you forfeit the right to say, I didn't have time.
This blew my mind when I found out. But did you know that over 80% of people have subscriptions that they've forgotten about? No, seriously, think about how many free trials you've subscribed to that you've probably never canceled. That's why I'm such a big fan of Rocket Money. Rocket Money is a personal finance app that finds and cancels your unwanted subscriptions, monitors your spending, and helps you lower your bills all in one place. Most people think that they're spending $80 on their subscriptions, when in reality, the number's closer to $200. When you're signed up for so many things like streaming services you use to watch one show or free trials for a delivery that you don't use, it's so easy to lose track of what you're paying for. With Rocket Money, you can easily cancel the ones you don't want with just the press of a button. No more long hold times or annoying emails with customer service. Rocket Money does all the work for you. Rocket Money can even negotiate to lower your bills for you by up to 20%. All you have to do is take a picture of your bill, and Rocket Money takes care of the rest. Rocket Money also lets you monitor all your expenses in one place, recommends custom budgets based on your past spending, and they'll even send you notifications when you've reached your spending limits. With over 3 million users and counting, Rocket Money customers have saved an average of $720 a year. Stop wasting money on things you don't use. Cancel your unwanted subscriptions and manage your money the easy way by going to rocketmoney.com/MeidasTouch. That's rocketmoney.com/MeidasTouch.
And you can't claim that you're owed 10 days notice in advance of trial for transaction evidence. I'm not really sure what that is. That's not a phrase that we use in New York, but that's some type of evidence that exists in Georgia. And clearly he's waiving that. And also that he's precluded from calling any witnesses whose statements were not provided to the state at least 10 days in advance of trial, other than the defendant. This could also apply to experts. So, it's basically saying, look, you have all these rights in Georgia, but you're forfeiting them. And you just need to know that. And I just want to make sure that you know that so that I'm protecting my record later down the line. And I just thought it was really interesting. There's some language in there that I thought was very interesting in there. She cites a case that talks about a language that says, the pleadings cannot be used collusively. Contrary to the view of some, our legal system is not simply an elaborate game of gotcha. The court does not endorse acquittal by ambush on the part of a defendant any more than it does trial by ambush on the part of the state, nor do we condone induced error. The object of all legal investigation is the truth, and procedural rules are in place to further such goal in an orderly fashion. And so it goes on to say, by filing a statutory speedy trial demand, this is what Fani Willis says, citing that case that I just read, by filing a statutory speedy trial demand, the defendants elected to proceed to trial without the benefit of the type of prior notice of the state's discovery and similar transaction evidence that would have otherwise been afforded to them. Similarly, that decision also cost the defendants the use of any evidence not timely served upon the state. It also prevents the defendants from arguing that they received insufficient notice of the trial in this case. Of the trial date in this case. Should the defendants in this case desire to proceed to trial under these circumstances, then they should be required to confirm it personally and on the record prior to trial. And then she says, the state respectfully requests that this court advise the defendants of the effects of the speedy trial demands and, et cetera, and respectfully submitted on this date. And so this is her protecting her record, which is exactly what she should be doing and reinforces the fact that of what I've been saying since day one, which is Fani Willis is a pro. She knows what she's doing, and she's just a great prosecutor.
And so, Karen, as a former prosecutor yourself, you spent almost 3 decades in the Manhattan District Attorney's Office. You're number 2 there, and many instances, too, you also had served as an acting Manhattan District Attorney. So you have more experience than almost anybody, I would say anybody in the country. As you watch the way Fani Willis is handling this and the motion that she just made, do you think that any of the defendants are now going to have a second thought about declaring the speedy trial? Like, do you think this has an impact, or you think it's kind of purely preserving the record? Or is she also kind of tactically saying, really, this is really what you want to do? Or is it really more just preserving the record?
I think it's a little of both. I mean, the government, the prosecution really is about the truth. They don't represent a side. They don't represent the victim. They don't represent any individual. It's about the truth. It's about justice, and it's about fairness. The defendant, on the other hand, really is about one person, and it's about themselves. And she's really making sure, prosecutors are true believers, good prosecutors, I should say, are true believers, and they believe in everybody's rights. They believe in the defendant's rights. And, so it's hard to watch someone do what they're doing and say, okay, just make sure, are you really sure this is what you want? And I'm protecting my record because this isn't in your best interest to go fast, but okay, I'm ready. So I think it's a little of both. But she knows what she's doing. She's an excellent prosecutor.
And when all of these co-defendants, a lot of them asked for this speedy trial, she used that as a way to say, well, after the indictment was handed down August 14th, she said, I was considering doing this trial March 4th of 2024. Well, now that everybody, not everybody, but you had Chesbrough, Powell, and I think Eastman, they're saying that they're ready to go. They want a speedy trial. She goes, you know what? If they're ready, everybody should be ready. It's a perfect way to use that against any claim by Donald Trump and others for delay, to say, really, Chesbrough is ready to go. and Powell's ready to go, and Eastman's they can prepare in less than 45 days. They're ready for this thing. So you're telling me you need 2 years? Come on, that's ridiculous. And that's exactly what she did. And she said, Judge, I actually want all of everybody should have to file a motion now. Why, if they want to sever, why this case should all not go on October 23rd of 2023. But as of right now, October 23rd, 2023, we should have trial commencing in at least one of these cases. It's going to be on TV. We'll do another duet about how this is going to be broadcast on TV and digital. We're going to cover it here on the MeidasTouch network. We should be able to get our cameras in there if other network cameras are in there. That should be easy. And we'll all get to see a lot of this evidence. So of all of the cases, even though I don't think Trump's is going to go on October 23rd of 2023, we can see the first verdicts in cases that are direct co-defendants of Donald Trump. We've seen co-conspirators, unindicted co-conspirator cases. We've seen, January 6 people. We've seen the terrorist groups like the Proud Boys and the Oath Keepers. But here you're going to see, as part of the RICO evidence, all of the evidence against Donald Trump as well in this public trial in October of 2023. But it's definitely, you got to get into the weeds of Georgia law to know all of these things. And I think here we got Fulton County District Attorney Fani Willis saying, just everybody, here's how it works. And for the judge who was only recently appointed, Judge Scott McAfee, who's been on the bench for 6 months, I think she's also just letting everybody know I've got command of the situation. So anyway, check out Legal AF wherever you get audio podcasts. Hit subscribe and go to MeidasTouch.com for more breaking news. Have a great one.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.